Someone make it make sense.
Probably a couple.
Hello, everybody, and welcome. Let me make sure my audio settings are normal because I was restarting my computer and sometimes it resets those things. Excellent. How are you guys doing? Wait, hold on. Let me just make sure all the right things are clicked. Okay, here we go. Cool. That should be good to go. Sometimes StreamYard just resets those things when you restart your stuff. So, excellent. How is everybody doing today? Franks, did we have a command for you yet? Hold on. If we have one, it would be Franks. Shout out to Denise. Shout out to Twiz. Love y'all. Let's just see here. Does Franks have one? We shall see when Nightbot gets here. Nightbot, where are you? Little guy. So he's having one of his little naps. Cute. Love it. Need some Z's. Hold on. What are you saying? Shout out to Need some Z's. Also, I'm hoping that you're failed in to the DNA testimony. What does that mean? Need some Z's? I'm wondering if there's a typo in there. Let me know. Also, you don't have a custom command either. So if you want one, oh, you wanted me to change it. If you wouldn't mind reminding me what you wanted me to change it to. I thought I did that. I remember you saying that, and I thought I did that, but I'm sorry, Franks. Let me know what you want me to change it to, though. I thought I did that. Hold on. Just let me know, and I'll do that right now. And hopefully Need Some Z's will also clarify what that question or comment was. Oh, dialed. Okay, it's all good. Dialed. Okay. Let me go back to it now. So maybe you're dialed into the DNA testimony. Yeah, so if you're referencing the DNA testimony like the transcript, we covered that. If that's what you're referencing, that we covered that one last time, like right after it came out. I think the same day, maybe. Yeah, it was the same day. So, right. Oh, yeah, that's brilliant. Okay, let me change that. Leave the gun, take the cannoli. Excellent. Any emojis with that one too, Franks? Would you like any? And I'm just going to update that. So while people are getting here, let me also let y'all know we have some big news on the channel. I now have memberships available. I'm just going to edit Frank's command here. We have memberships available now. We've got 2 tiers so far. And as I've learned, when you do these things, you have access to more perks and stuff as more people join. So leave the gun, take the cannoli. Okay, let's see here. Yeah, we did. I read, by the way, Need Some Z's. I read the entire thing in one sitting. What is it, like 175 pages? I read the entire thing. It was like 7 hours or something like that. Maybe longer. And I have finished timestamps as well for that too. So yeah. Let me just make sure I get this right for Franks here. Okay. Would you like a period or an exclamation point at the end of that, Franks? So yeah, so we do have memberships now. Here's the thing. So one thing that's really exciting is, you know how you guys are familiar, I'm sure, with how you can with the memberships, when people, you get the badges, right? For like people, when time goes by, as time goes by. And so I was like, what should we do? So what it's going to be, and I'm still working on getting all of them set up, although because it's as time goes by, you know, I've got like, I think the first 6 months or whatever done. But what it's going to be, because we always talk about squirrels of the world. So the badges are going to be squirrels of the world. So all these different squirrels from all around the world, and they're all going to be really cute, obviously. And so that's going to be the badges. It'll be really fun. So I've got, like I said, I've got a couple set up already. And then I can add more perks, such as like the custom emoji. There's a limit on that until more people join, or until I don't know if anyone's joined, but you have to have a certain number of people join before you can add more stuff. Okay, I figured as much, but I wanted to double check just in case. All right. Should we do a let me just see if there is like a I know there's like a squirt gun. We'll see if we've got some sort of emoji there that goes along with it. Let's see if there's a cannoli. Okay, no cannoli, I don't think. Let's see if there's something similar. Some sort of similar dessert. I'm not seeing anything on here, not surprising. So we'll just go with this and see what Franks thinks. So if anyone wants to try her new command with a exclamation point Franks, we've got our Franks is our first, to my knowledge, our first member. Welcome, welcome, welcome. Yay! That is so exciting. Oh my God. Can you guys see the badge on y'all's end? Because I don't see it on StreamYard, but that wouldn't be surprising to me. I wonder, can you guys see the badge? That's so cute. I mean, I'm remembering it and it's cute. Shout out to Iowa as well. That's the only one they got, yo. You know how YouTube be. Look at that. Look at her. Her name is in green in the chat. That is yay. Oh my God, that is so exciting. Awesome. Welcome, welcome, welcome. Sweet. So yeah, so I made it so that the 99-cent tier, which is the cheapest you can do, you know, is going to be like stuff that is just fun. Like we're going to have the custom emojis and the badges. And you know, again, I can always add more stuff to it too. Just because I figured like, you know, the Squirrels of the World thing is going to be so fun to see everybody as they join. They get to watch their badges change with different squirrels. It's going to be amazing. And like, I'm super excited. I'm super excited as people join to see the time go by and then get to see the different squirrels. So awesome. So we're going to roll with the squirt gun now. And then also, oh yeah, what I was going to say also, so tomorrow's the big day for Karen Reed as well, guys, after all the stuff that happened last time. So here's the thing. So tomorrow, I'm sure there's going to be lots of people streaming that live. I'm going to let y'all decide. And as more people get here too, we can maybe have people vote, but I can either stream that live as it's happening, or I could stream it, you know, in the evening or whatever. Because, you know, I don't want people to feel like they're torn because they want to watch it elsewhere. And there's lots of other places. I totally understand. And, you know, I don't want to put people in a position where they feel like whatever, you know? So I can do either way, but if you're like, no, I want to watch it live, you know, and we want to watch it here, you guys just let me know. Cause I know how some places, I know what people have voiced previously about how, it can be with Karen Reed on other channels in the chat and stuff like that. Hi, Candace, welcome. We have memberships in case you didn't see. And welcome our first member on the channel, to my knowledge. I don't think anyone had, because I just got this up and running today. Franks, we love it. That's super fun. So yeah, so y'all let me know if you guys do want to watch it live tomorrow, and then we will do that. So yeah. And so so then also, so we're going to get started with these documents. Again, we started with the transcript. That was the last one that we streamed because that had just come out and I was like, oh my God. And so we're going to go back and cover some of these court filings that came out during the Zachary Hughes trial, because we were all up in that piece, as kids say, or some people say. I just said it. How about that? I just said it. So does anybody have a preference in terms of, would y'all rather we start with the order on the Franks hearing, or the order on the IGG, or what were the other ones? Let's just see here, because he kind of grouped them all. So we got the order on the motions to suppress, and then it's grouped. ATT, Google, USB, Apple, and Amazon are all grouped together. Boy, that tells you something, doesn't it? Right there. And then there's a separate one for the arrest warrants. And then there's Frank's, and then there's the genetic information. So does anybody have, and there's nothing new that's come out since the transcript. So does anybody have any thoughts on what they'd like to start with? I figured the Franks is probably, that's why I put that in the thumbnail, because that's sort of the thing that we were all expecting to hear maybe something different about potentially. So is that tomorrow? Wait, bench trial. Mullins, that's the one, the judge? Wait. Oh, Mullis. Bench trial. I'm not sure what that is. Which one is that? Bench trial, though. That's interesting. Todd Mullis. Was he the one in Iowa with like the Rake thing? I think that might be who that is. So do you guys have any thoughts on what we should start with here with Franks or the okay, yeah. Okay, gotcha. Okay. That's probably civil, right? I feel like I think he already had his criminal trial. I'm trying to think. But if nobody has any strong feelings, we'll probably just start with Franks, because I already have it up. And also because in celebration of Franks, right? That just makes sense. That just makes sense. And I'm just going to grab some more water here before I get going with the reading, because y'all know how it is once I get in the zone with the reading. So give me just a sec. Okay. Cool. Couldn't agree more. Twiz is saying this Franks is cooler than that Franks, though. Yup. Oh, okay. This is to get a neutral. Interesting. Yeah. So anyway, but y'all do let me know as you guys think about it. If you guys, apart from Franks looks like she will be tied up with the Mullis bench trial. But I mean, maybe having said that would be a vote for Karen Reed in the evening then. Because I was saying I could either stream it while it's happening live, or we could do it after the fact, like in the evening. So you guys just let me know what you guys would like. And maybe if we need to do a poll or something like that, we can. But yeah, usually you guys just sort of weigh in, and then that can help me make that decision, because it's whatever you guys want. I have the availability, so we will do whatever you guys want with that. All right, so we will start here, though. The order on the defendant's motion for our Franks hearing. Okay. Twiz says he can be here. Awesome. Smexcellent. George'll stick. Shout out to George'll stick. Okay. Tree fitty, right? Right, George? Full stick. And, when you get, here's the thing. You got to appreciate the creativity, right? Because, like, that's not your typical standard fare. Using a corn rake, like, wow. Really got creative there. Yep, tree fitty. And speaking of which, we will do a follow-up with all the rose petal. I feel like there's going to be some more stuff coming out. That's just my feeling. So we will definitely do another installation on that one as well. I mean, yeah, right. A corn rake. Yeah. Great question. How is it different from a regular rake? Yeah, Google it. I'm going to Google it too. That's a good question. Let's see, corn rake. By the way, I love corn. It's one of my favorite foods, corn on the cob. And being a squirrel, you can probably imagine like people basically that know, like my family, for example, right? They know like, don't get me around corn on the cob. Like if you get me around corn on the cob, it's like a safety hazard. Like unless you're wearing like a hazmat suit, you will get injured because the corn is going to go flying fast and furious, and I will go through those corn on the cobs, whatever it is, like nobody's business, and I just will like I just devour. I just love it. But like half of it probably flies in the air, and then the other half gets eaten. It's just the way it is. So let's see. I'm going to pull up corn rake. Oh, okay. The corn rake. I see. That's kind of like that old fashioned type of rake, like in that, that American Gothic painting thing that you guys know. Okay. The corn rake. Interesting. Wow. Yeah. It definitely looks more. Here's what I would say. The tines, you guys know, like the tines. If you imagine like a leaf rake, which the tines are like flexible and there's a lot of them and they're skinny. This rake looks like it does not have give to it on the tines. There's like 4 tines and the tines look rigid. And so I can imagine it would do a lot more damage than your standard leaf rake. Yeah, like a pitchfork. It's like a pitchfork. I wonder if that's the same thing. Yeah. Mm-hmm. Yeah, I wonder, is it the same? Let's see, pitchfork versus, because we like to learn here. Pitchfork versus corn rake. Similar to a pitchfork, it says, but what's the difference? Looks like they're pretty similar. I'm not seeing anything telling me exactly what the difference is. What, if any, difference there is in Hauslong. Oh, wait, wrong thing. Yeah, great question from Need Some Z's, but to Denise there. What are your thoughts on these orders? Agree, disagree with any? I will say I've already seen Denise weigh in, and it's in line with what other attorneys have said, which is that they're not surprised they were denied because they're so rare. So I've seen that. But good question though about motions in limine. I mean, certainly they will make motions in limine. You know what I mean? That'll be their next line of defense. That's interesting. The wife had 6 impale wounds and the rake only had 4 tines. Huh. Wait, he's saying that she removed it from herself and then fell on it again? No way. Really? Is that what he's saying? The dude, the husband? That is interesting though. The 6. That is interesting. So he's appealing the jury verdict. That's what it sounds like. Interesting. Yeah. Huh. Right. Yeah. Reminds me, it's reminiscent of Ellen Greenberg, isn't it? There, Frank's reminiscent of Ellen Greenberg. Anyone who doesn't know who that is, let me know, and I will give a brief little rundown on what happened with that. Oh my God, that is so cute. Neeson Z says, when I was a kid, we had a dog who would eat corn off the cob like a human, 1 paw on each side. Oh my God. And he'd eat it in a row like people do. Oh my God. It sounds like he was better at eating corn than I am because I just make a huge mess of it with all the squirreliness. That is so cute. Pick raspberries off the bush. How cute. Wow. 3 separate times. Yeah, that definitely sounds like somebody was mad. You know what I mean? I don't think the motion in limines there's not, I mean, I just checked the docket. The most recent filing was the transcript. So the motion in limines are not out yet. And I don't even think they're due for a good bit. Yeah. Well, and also, hesitation wounds. Well, I don't know. I feel like the post-mortem wounds, though, kind of seal the deal on that. Right. Oh, they're just listed. Okay. Right. Okay. Got it. Wow. I'm surprised they were filed that quickly. So they're on the case summary. So they might pop up tomorrow. So we might have a big day tomorrow with Karen Reed. And having said that, it might be worth covering Karen Reed live in case those filings do come up where we can read them, and we could read them tomorrow night. Oh, the state has filed some. Interesting. The state has filed some. Oh, I am very curious about that. Holy mackerel. Okay. Yeah, speaking of which, here, let's see if we can pull up the latest scheduling order and take a look here. I don't even remember when that was last updated, but let's just see here. Now I wonder, it might have to do with expert witnesses, guys. Extended deadline to file motions in limine. February 24th. There it is. Okie dokie. And they will be heard on April 9th. Okay. Let's see when and what did it say here? It said the response is filed on March 17th. Okay, let me look back and see if I can find the previous scheduling order. Anybody knows that date? I'm not seeing. There's so many filings though. So, there's a scheduling order for ICR 12 motions. That's not the correct one. I wonder if the due date is in the summary. Right. And the thing is too, and I commented on this when we were reading the transcript of the IGG hearing, it was clear to me that some of those objections from the state, well, it seemed like were being sustained, and he wouldn't even let Anne kind of make an argument against that objection from the state. And it seemed pretty clear to me that it's because he didn't want it even to be put on the record for the public, because he already knew he was going to deny it. Yeah, I'm not seeing, where is the, there's the order extending deadlines, but that's the one we just clicked on, I believe, from 131. Oh no, the amended order. So that's, yeah, so that's 131. So I don't know. So I don't know when the defense deadline is for motions in limine. But again, their deadline for their response to the state's motions are March 17th. Okay, so okay. All right, so introduction. I don't know that we need to read the introduction. I think we all know why we are here. So, okay, these misrepresentations or omissions, according to defendant, affect the validity of 17 different search warrants. The state responds that the defendant has failed to make the requisite substantial preliminary showing under Franks that 1, law enforcement either made false statements or omitted material information knowingly and intentionally or with reckless disregard for the truth, and or 2, that the false statements or omissions were necessary to a finding of probable cause. And then we've got a couple footnotes here. We've gone over Franks v. Delaware many times. Footnote 2, there was a total of 25 search warrants issued between December 23rd, 2022 and August 1st, 2023. For each issue analyzed in this order, the court has identified the date range for specific warrants defendant claims are implicated. And then this is referencing the motion for a Franks hearing, and that was accompanied by a memorandum and a USB containing exhibits, 1,951 pages. To properly consider a Franks motion, the court must necessarily consider the search warrant affidavits. And then I guess that footnote, let's get to where that continues. Search warrant affidavits in their entirety to determine whether probable cause is affected. Consequently, the evidence considered by the court for this motion is defendant's revised exhibits as supplemented by exhibits D2, D3A, and D3B from the original exhibits. Oh, right. And the amended memo. Remember when he was like, be more specific with your page numbers? Yeah, that's the amended memo. Okay. So now, a hearing was held on January 23rd. Okay. Interesting. What's he going to say about in the interest of evidentiary efficiency? Wow. The court permitted a full Franks hearing on the motion only insofar as it pertained to the, this makes no sense. Oh no, it's too early to go. We just got going on this. Oh dear. A full Franks hearing only insofar as it pertained to the omission of the IgG information. Pardon? On the remaining challenges, oh wait, there's a footnote. Hold on. Oh, this was identified as issues 5 in the defendant's amended memorandum. Great. On the remaining challenges, the court permitted argument on defendant's proffer as to whether defendant had satisfied his burden to warrant a subsequent Franks hearing. Footnote 5. The court notes that in response to some of the Franks challenges, the state submitted and argued evidence that was not included in the defendant's proffer. While this evidence can be considered at a Franks hearing, this stage only permits the court to consider whether a defendant has made the substantial preliminary showing under Franks to warrant that hearing. Was this like when, is he referencing here like when Ashley Jennings fucked up and mentioned like shit that wasn't included in the prof? I mean, that's, yeah, I mean, yes. Remember when he was like, haha, I can't consider it. The court should not give the government an opportunity to present its evidence on the validity of the warrant without converting the hearing into a full evidentiary Franks hearing. Yep, yep. Including full cross. So, but remember, like he helped her out a couple times with that, right? And it's like, that just goes to show you, man, because he should have, like, why? I'm sorry, but don't do her job for her. Let her make those mistakes and then give them the full hearing. And in fact, he even said, no, don't keep going because otherwise I have to give them a full Franks hearing. It's like, oh, right. I don't know how to do my job. So like, yeah. Like, oh my God. Thanks, Twiz. Prometheus was the health data thing. I don't know. I'm curious what you mean about that, Neeson, because that was just, I don't know that was really significant. I don't think that Ann Taylor was even alleging that it was accessed. I think the point was just to say in terms of like the whole, part of the argument with like the IgG is like the invasion of privacy, right? And all that. And I think that, because I kept getting annoyed when I was reading the whole thing about the health data, because I was like, that's not what they were looking for, right? That doesn't help them find a suspect. But the reason that you would be bringing that up if you're the defense is just because that's another way to try to argue that they could have accessed health information, which is considered to be, again, an infringement on privacy and whatnot. And part of the thing was like, the general public, what are we willing to accept in terms of privacy? And I think that's why that was brought up, as in like, that's how easy they could get to that information. I don't think it was accessed, to be honest, because it wouldn't actually have helped to find a suspect. But also the defense has not even kind of said that they did. So, because I mean, the thing is like that, if they did access it, I mean, oh, the yes was for me. Okay. Yeah. Because when we were reading through that transcript, and I already kind of knew this anyway, but like from reading through this transcript and again from hearing them talk about it, like the tacking on of the health thing, it literally would just be like, you know, the best you could get from it is like, you know, likelihood for maybe being at risk for Alzheimer's and stuff like that. That wouldn't lead you to a person, and that wouldn't really help law enforcement if they did access it. Okay. Yeah. And that would be if they intend to introduce it at trial, right? Like, I don't know that, again, from what we heard, and who was it that was talking about that? I think it was Leah Larkin. It doesn't seem like that Prometheus thing would even yield anything too crazy. You know what I mean? Like, to where, and I don't think it would be relevant anyway. I don't, because, you know, for evidence to be admissible, it first has to be relevant, right? And so they would only make a motion to eliminate to exclude something that would be admissible as evidence. And I don't think it would. Right. A violation of his rights. Yeah. Right. Right. There's zero evidence that nor did they look at any health info. Right. Right. Yeah. So that's what I was saying, right? That, like, just the fact that they could have had access to it. So that's going towards, again, that like constitutional rights, you know, like I was saying with the IgG, and not so much like for example, there was no motion to suppress, like, there, yeah, that, hopefully I'm kind of making sense. Like, in terms of just the potential problems with IgG, right? It's just highlighting here's another thing that could be done, but it doesn't, they aren't saying that it did. And, you know, it's just like the fact that law enforcement could have accessed it is where the problem would be. Right. Yep. Denise saying the same thing. They just want to bring it up to say they could access it. Yep. 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 And it's a violation of the Fourth Amendment right to privacy. Yep. 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 What if they asked, who's SC? Right. 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 Yep. Yep. Yeah. It was just to try to support that argument with the constitutional right and privacy. That was my take on it the entire time. Oh, okay. SC. I don't know. I don't remember seeing that. Maybe it's in one of these documents I haven't read yet. I remember the one that we covered from the transcript, the one that was the mixture that was like 19 point something, something. And then we gave it letter F just to make it easier, because it was like A was for the sheath, B was for the handrail, C was for the cigarette, D was for the blood on the glove, E was for the dad, and then F was for the mixture, and then G was for Georgial stick. Okay. I don't remember SC, and I read the whole fucking thing. I mean, male A, I thought was like what they were saying for the sheath, right? Oh, interesting, Twiz. Okay. I mean, I can do it. I can pull it up and do a control F myself. Let's see. It's pulling up SC. So crime scene, Moscow, scour, scope, obfuscate. There's 118 matches, but most of them are just words. This is going to take forever to click through all of them, so I'm not going to do that. Oh, okay. Do y'all remember which witness that came up with? Okay. Yeah, the hearing is what did it say? April 9th was the hearing for the motions in limine. Let's try this again. We'll add it with the periods here. South Carolina. I see. Okay, I see. All right, here we go. Is this okay? This is talking about how they were able to confirm that they'd access those other databases. Okay. Okay, there's an email again. I mean, so it is. Yeah, I read this. I just didn't remember it because there was a lot reading through again. Yeah, 175 pages. Okay, but there's an email communication as a match list from the perspective of somebody who only used the initials SC. Oh, okay. I remember this. What this read like to me, y'all let me know what you think. What this read like to me was what did it say it was through? GEDmatch? No. Okay, GEDmatch is a super open. Okay, GEDmatch is just a super open database in that way. Any kit in the system that is public, you can see their matches. The one exception, however, is that if there are forensic kits, and I'm a layperson, I'm looking right. We knew all this from Gabriel Vargas, but there's an email communication from the perspective of SC. Here's how I interpreted this as I was reading it. How I interpreted this is they did that thing as described by Gabriel Vargas, where they like pretend to be a layperson, right? So that they don't, so that then they have access to all the shit, right? And then they also, whether it was on purpose or not, but just they also avoid paying the fee. I remember this whole thing very well about the forensic kits, but they can upload as like a consumer. So they would make a consumer profile, right? And that's how I interpreted it. Right. That's what I thought too. Didn't they have to use a name, so that's what they used. Yep. Yeah. That's referencing how law enforcement did that. Okay, so right. And we were on this footnote here, footnote 5, about Ashley Jennings and her other evidence that she was going to, yeah. Consequently, on these challenges, the court is only relying on defendants' exhibits and parties' arguments regarding why or why not, based on that proffer, Frank's hearing is warranted. Yeah. All right. And I was complaining. I was like, he shouldn't have been helping her out like that. Anyway. Okay, on the remaining challenges, the court permitted argument on defendant's proffer as to whether defendant had satisfied his burden to warrant a subsequent Frank's hearing. The court then took the matters under advisement. The court concludes that search warrants were not invalid based on the omission of defendant's identification through IDG, because that information would have only bolstered probable cause for the searches. And that's what he said in the hearing. You guys, I'm sure, remember when he's like, but wouldn't that just add to the probable cause? I will tell you guys that that did not make sense to me. I thought that when he was asking that question, it was sort of as for like a mental exercise, if you will, like theoretical. I didn't understand. I don't know. It doesn't make sense. I mean, basically it's like circular reasoning to me, right? Because it's like saying it would have bolstered the probable cause, but not if the IgG was problematic, right? Like, in other words, it's like if they didn't also have like a motion to suppress for the IgG, right? It'd be different. But there's also a motion to suppress for the IgG. So it's like the IgG is not just the first thing that would be like the chain for like the fruit of the poisonous tree, but also, even if they weren't going with any of that, right? Even if there was no fruit of the poisonous tree or whatever, like, in other words, they could still have filed a motion to suppress the IgG just on its own, by itself, right? So in other words, if the defense is arguing that that was invalid and was not should not have been relied upon for probable cause, how then could it also bolster probable cause? And my point here is this: the fact that he asked that in the hearing and then he's restating it here, to me reads like this. It reads like he only can see it as bolstering probable cause because he can't imagine the failure with it in the first place, right? Because if it was a failure in the first place, and even if you were like considering it to be problematic, again, just picture by itself a standalone motion to suppress for the IgG, right? If you were considering that maybe that was a problem, then it wouldn't bolster probable cause, right? The only way you can make this argument here, I guess not an argument, but make the statement, they being the judge, is like if and the fact that he asked it at the hearing, right, is like the inability to even consider that it could have been problematic in the first place, because this only makes sense if you're like, it was completely credible and there's nothing wrong with it. And in fact, it would have bolstered probable cause. So hopefully, is that making sense what I'm saying here, guys? Welcome back, Just Beth. Happy to see you. That's funny. South Carolina. Right. But only if the IgG was valid, right? Like, again, the defense is saying, again, they have their own motion to suppress just for the IgG. So, you know what I mean? You're very welcome, Just Beth. Yeah, Denise agrees with the circular reasoning. Okay, glad it's not just me. Right, exactly. Yes, Twiz. Twiz is saying if Hippler fucked the defense, if IgG by itself wouldn't give PC, it didn't matter if they franks it because PC would still happen. Exactly. Right. And therein lies again the circular reasoning for sure. And Just Beth does not have a command yet, but please let us know if you're still with us, if you would like a custom command. Thanks, Twiz, for putting that in the chat and reminding me to ask her that. So Sue. I don't think we have a Sue command. Who's Sue, though? Right. Yeah, we still never got answers about the middle people, right? Like, I kept waiting for that the whole transcript, because the way it was referenced in the hearing was like they learned about it that morning, right? And now we've read the transcript, and initially I thought that Mr. what was it, Hillspeth or whatever, Hudgens, whatever, that dude was the middle person, but party people, whatever I was nicknaming him, but no, he was not. So we don't know who those people are. I'm not sure what you're talking about, Twiz. Okay, cool. Welcome, Sue, if you exist and if you're here. Okay, so all right, so here we are. As to the remaining challenges, right, the circular reasoning. As to the remaining challenges, the court finds defendant has failed to carry his preliminary burden under Franks and therefore denies his motion for Franks hearing. And here's the standard. Wow, that's a very short paragraph. In a Franks motion, the trial court's determination as to whether a representation is false and whether a misrepresentation or omission was made knowingly and intentionally or with reckless disregard for the truth are factual determinations reviewed under a clearly erroneous standard. Whether a misrepresentation or omission is material is a question of law freely reviewed. And then analysis. For a search warrant to be valid, it must be based on probable cause. And then, of course, with Franks v. Delaware, right, the Supreme Court held that a defendant can void a search warrant and suppress the fruits of the search when the affidavit used to procure the warrant contains a knowingly and intentionally or recklessly false statement that is material to the probable cause determination. That's from U.S. case law there, as we know. So, quote, where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included by the affiant in the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held at the defendant's request. And that's exactly why we heard Ashley Jennings over and over again say, it wasn't necessary. It wasn't necessary. And it's like, but she said that, I mean, just y'all, she said that about literally every single thing in the PCA. And it's like, I made the joke at the time, make it again now. It's like, well, if you remove all of them, what are you left with? The word the? I mean, you know what I mean? Like, whatever. Anyway, no point. Okay. Idaho has adopted the rule of strap established in Franks and extended it to deliberate or reckless omissions of material exculpatory facts in affidavits. Quote, an omission of exculpatory facts is material only if there is a substantial probability that, had the omitted information been presented, it would have altered the magistrate's determination of probable cause. And we heard that discussed at length. That's coming from State v. Peterson. Oh, here she is. Oh my God, twins. Look at this. She just materialized. Welcome, Sue. Yes, and the 5 minutes, you know, that's just to weed out the trolls. And honestly, it's worked great. I don't have any mods, as you guys know. It's just me and Nightbot. But so far, we've only had one troll and one person that we've ever had to boot. And many of you guys know who that is because he's a legend on this channel. Shout out to Glenn. And, you know, because that's the thing. And I see that with a lot of channels. In other words, it's instead of having to put a whole bunch of like rules and you know, the 5 minutes, you know, I understand that's probably annoying when you're like, oh, I want to get in the chat, but like, you know, it does make it so that people that want to just fuck around don't bother, right? Yeah. Yeah, I agree, Denise, for sure. Frank saying real friends are overrated. Awesome. But welcome, Sue. Welcome, welcome. So, and the thing too is that it's clear to me that, and we're going to see more of it, that again, like even what I mentioned before with the circular reasoning and that the fact that he said it at the hearing too, that he already has his mind made up before he heard any of the argument. Like in terms of this, right, Denise, like it would be great if he listened and cared about what they said. I mean, and I don't even know that it's that he didn't understand it. I think he just didn't care. Like he already had his mind made up, right? Like the thing of like, he thinks they have the right guy, so it doesn't matter. And that's not how it's supposed to be, right? It's awful. It is very weird that they don't have to show their work. There's a lot of weirdness. Welcome back, Heather, my friend. We were just talking about Glenn. You're just in time for the Glenness of it all. 22 seconds. According to Twiz, that's a long time. And Heather, in case you didn't hear it, we do have memberships now. Whee! So there's that. And the badges, as time goes by, are scrolls of the world. So that's fun. For sure. Yep. Yeah. There is some real issues for sure. For sure. Yep. 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 And I hate that. That's not a good feeling, right? And that's true. Yep. Heather has a message for Glenn. Yeah, you're absolutely right, Twiz. And that's the thing, like, because the standard is so low for probable cause. Well, having said that, right, like it still needs to be done properly. But like Peter Trago said, right, he said that's why, you know, he said like the magistrates will just put a rubber stamp on it without really considering it. And that's why he was like, that's why I argue to a jury beyond a reasonable doubt. And I really make sure I hammer that point home, because basically the way he was putting it is like, it's always going to come through. Like they're always just going to let it through. Right. And so because of that, that makes that standard even more important and more stringent, right? Like, in other words, if you imagine that there was a more of a substantial filter for things even getting in the first place, or for an arrest in the first place, right? Then I think you should still have beyond a reasonable doubt, but you would at least know that like some of the evidence has been potentially weeded out if if things were done improperly by law enforcement, right? Like, dealing with like the motions to suppress. But the fact that this shit isn't really fully considered, like as it pertains to Judge Hippler, right? Like, again, I have the impression that he already had his mind made up. Did he really give it a fair shot? I think maybe he wanted it to appear that way, but let's keep reading because we will get some more hints to this. And this is kind of, therein lies the problem, right? It's like the judges are just going to kind of like let it on through and then put it in the laps of the jury, right? Put it in the laps of the jury to make that final call. Yeah, the states have they come out? I mean, we just pulled up the majigger. Yeah, and I've said it before and I'll say it again. I fully expect this case to go to the Supreme Court because of the novel issue with the IGG. I'll refresh this though and see if they did become available. The motions in limine. No, the most recent thing that I'm seeing is still the transcript on that. So based on the titles, okay, I'll take a look at the titles. I had a feeling it was going to have to do with expert witness testimony. Let me just take a look here. No, I'm not going to, let's do it the fast way. That's what she said. Okay. So the first one, state's motion to eliminate alternative perpetrator evidence. That's got to be the blood on the glove and the blood on the handrail. Maybe the blood on the cigarette. State's motion to eliminate neuropsychological and psychiatric evidence. That's interesting. Now remember, we're still waiting on the health, whatever the shit that was going to be released that was under a protective order. That hasn't come out yet either. State's motion to eliminate alibi. Wow, interesting. I thought that was already like not a thing because it wasn't, interesting that they're still doing that. And then state's motion to eliminate readmissibility of demonstrative exhibits and memorandum in support of demonstrative exhibits. I wonder what those are. Interesting. And then motion to exceed page limit. That's got to be for something else that hasn't come up yet. Unless it's for the memorandum, maybe for the previous filing here, maybe. Right. Well, I mean, but are you saying that the defense is going to try to present the blood on the sheath as an alternative perpetrator? That's why I didn't name that, because I don't know that they're going to do that. All right. Well, hold on. Sorry. Hold on. I just got my wires crossed. The blood on the sheath. I guess they could. I mean, I don't know how far that would go, though. Like, I think if you're going to argue that to a jury or present that to a jury, you need unknown male letter name or unknown female potentially, right? But like, you need it to have a thing. Like the blood on the sheath, again, we talked about this, but it has to be from the victims because otherwise it would have been given a designated, and Ann Taylor didn't even try to say like, like the other things that weren't like, how come you didn't, for example, right? Like unknown male B and unknown male D. And it's like questions about like, why weren't those put into codes? Well, the blood on the sheath, she didn't even say anything about that. Just it only came up in terms of where was it tested. Yeah, and that's a good point, Heather, because that is funny, right? Because we all know that yeah, so they're trying to use that as an argument, right? Because it actually isn't, by the standards that we've heard this talked about at length, it actually doesn't count as an alibi defense by the definition set forth. Well, okay, because essentially they, Ann Taylor and the defense counsel, right? They couldn't really be specific enough. Like, in other words, that was, again, I kept saying that like that ship has sailed, right? Judge said like alibi, not alibi, right? Because it didn't actually really meet the criteria. But it's funny that now the state's going to call it that, maybe if they can use that in a motion to eliminate. Sheath does not, I think Sheath has no E on the end, but I do agree. Yeah, I think it's the victim's blood. Plus, it makes sense, right? I mean, just the knife sheath being where it was in the scene, it's gonna have, you know what I mean? Like, it would either be victim's blood or, you know what I mean, or victim's blood and perpetrator blood. But like, you better believe that if they had found anything that could suggest it also belongs to the perpetrator, that would have come up. So, they can't say they tracked him to Pullman with cell data and then say the defense can't use it. I mean, we'll see what they say. They can't stop. I don't think, Denise, let me know what you think. I don't think that this motion eliminate re-alibi, I don't think they can't stop the cell phone evidence from coming in, right? They can't, right? So this would be probably as it pertains to trying to suggest, like with the stargazing or going running or what have you. Now, let me give you an example with Alex Murdaugh, okay? This is an example because they were wanting to run an alibi defense, as an affirmative defense for him. And the alibi would have been that he was at his mom's in Alameda, right? Now, what happened was then they were able to unlock Paul's phone, and then they got that Snapchat video. And there were some other things that happened along the way, but basically everybody was able to identify his voice in the video, and they were able to definitively prove, like, hey, you weren't there, you were instead at the crime scene. But so in other words, they couldn't actually run with like an alibi defense by definition. What they were able to do is still try to suggest to the jury that he could have possibly been at the house and then left and got into Alameda, and they were going to try to use the timeline to say both could have been true. But they couldn't say he was actually at Alameda when the murders happened, like, if that makes sense. So it's like a pseudo alibi, but like not a legitimate, like in terms of what is required to actually call it that. So it's like suggesting an alibi, but it's not like an actual alibi defense, if that makes sense. So I don't know if that's helpful. Right. Exactly. Right. So my thought, Heather, again, I agree. So my thought there is like, if there's something else that they were going to present, like the going to the, like going running or stargazing, something like that. Right. So the defense response to the motions in limine is due, what did it say? Oh, I clicked out of it. It's sooner than that, Twiz. Their deadline for their response is due. Where'd it go? Okay, hold on. It's due, just loading, on March 17th. March 17th is when the responses are due. March 17th. So that's when we will hear the defense responses in terms of the court filings, and then they will argue it on April 9th. Hi, Rochelle. Welcome. Do you have a command? Oh, good. Okay, good. Excellent. You do have one. Excellent. Welcome. That's funny. Yeah, I'm interested in that as well. Yeah, I do it in that at the end of the day. That's DSN with the dog in its mouth. I'm sure that comment came in when I was talking about Alex Murdaugh. That's DSN. DSN. Shout out to DSN. Hey, we've got a bird in its mouth. Here, we'll play it for fun because we were just talking about it. I should have done it. I was being a bad squirrel. I didn't even play this when it would have been super appropriate. Okay, hold on. Hang on.
Hey, he's got a bird in his mouth.
There we go. Shout out to DSN. We love DSN. That's a good question. It's a good question. And I mean, the other thing that's interesting too, right, is like it's not an NGI defense either. So unless yeah, well, okay. Unless it's maybe, okay, think of it kind of like the alibi, right? Unless it's one of those things where they kind of, maybe there is something in there, right, that they would want to present to the jury that could suggest that route. Similar, like I said, just similarly to like the suggestion of the alibi, where it's not like that exact affirmative defense, but like the jury could still be persuaded type of thing. Awesome. Love it. Love it. We love you, DSN. Right. Exactly. Mitigating factor. Right. That's a good way to put it. Right. And remember, right? Like we talked about this before. It came up in another court filing. I'm trying to remember which one it was. It was one of the Jay Logsdon filings. And I thought it was really interesting how Jay Logsdon said that in the past, like any type of like mental illness or psychological disorder, whatever it is, right? That in the past, it's been used as both a way to say, look, this person's crazy. They would definitely kill again. But at the same time, it's also used to say they're not guilty by the reason of insanity, and it's used as a mitigating factor. Like I think it was actually in the death penalty motions because I covered all of those. It was used as both. Okay, here's what it was. It was used as both an aggravating factor and a mitigating factor. I mean, yeah, right. So, but that's a good point because remember, some of this could be as it pertains to if he's convicted, right, this could be as it pertains to the bifurcated portion of the trial, which would be, then when you would present your mitigation evidence, could be. Right. That is interesting, Heather. Heather says, my sister had the gene that is linked to others chewing being intolerable. Wow. Amazing that there's a gene for that. Right. Exactly. Yeah. That's funny. I hope the vegan thing doesn't come up at trial just because it's going to be annoying. As a vegan, I will be annoyed at what people will incorrectly say and whatever else. I was annoyed. I was already annoyed when that came up. I was like, God damn it. They tried Twiz. That was one of, again, I cover all the death penalty motions. That was one of the death penalty motions. One of the grounds that they were citing was the speedy trial. And, those have already been denied. I did not think the speedy trial that was, I think, their weakest one in terms of the death penalty motions. I thought the motion to trifurcate, I think the trifurcating was a brilliant idea. I'm all for it. And actually, when I was covering them, I ranked them and what I thought would be maybe had the best chance of being successful to the least. I thought a speedy trial was like the least probably. Well, of the ones that were specific to this case, because you also have your generic, like, standard death penalty motions. What do they call it? Like your par for the course. There's another term I'm thinking of. But anyway, in terms of specific to this case, the speedy trial I thought stood the least chance of going through. That's funny, y'all, with Jeff. We haven't seen Jeff in a while. Okay, so let's keep chugging on. We're chugging right along here. Okay, the analysis under Franks is a two-step process. The first step considers whether the defendant has made a substantial preliminary showing that the affiant knowingly and intentionally or recklessly falsified or omitted information from his or her affidavit. While the Franks court did not define this burden precisely, it is generally held to be something more than conclusory allegations, but less than proof by a preponderance. Courts have said this requires, quote, direct evidence of the affiant's state of mind or else circumstantial evidence of a subjective intent to deceive. Now, what's tricky about this, guys? I'm going to read this again. I want you guys to let me know. Why does this suck? Okay. Courts have said this requires, quote, direct evidence of the affiant's state of mind or else circumstantial evidence of a subjective intent to deceive. Does anybody need a refresher on what counts as direct evidence? Because think of it this way. Direct evidence is not needed for probable cause for the defendant, any defendant. Direct evidence is not needed. However, in order to try to say or to make an allegation that, again, any of these statements, right, in the affidavit were made, intentionally or recklessly falsified or omitted information, in order for that to be the case, right, check out the difference here, right? Then the defendant has to show that there's direct evidence of the affiant state of mind. The affiant state of mind. So two things here stick out to me. Direct evidence, first of all, again, if anyone wants to, we can do like a little quiz and whoever wins gets 1,000,000 scroll points. Who wants to put what direct evidence is in the chat? And then the second thing that sticks out to me, the affiant state of mind. Really? 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 Like, dear diary, today I'm going to falsify evidence so that we can get probable cause for an arrest. Like, what the fuck are they? What even, like, you know what I mean, guys? Like, what? Y'all are the best. Twiz, okay. Direct evidence is evidence that directs you as a suspect. I think you're joking. I think that's funny. Good job. Does anybody want to like define it? I mean, right? That's what I'm saying. Dear diary type of shit, right? So direct evidence, right, is going to be, because it's the same. Direct evidence is like literally like eyewitness testimony of somebody seeing the person doing the thing, or like a video of the person doing the thing on camera, right, where you can actually see the person. Other than that, it would be a confession, and that's it. So what's direct evidence? Seeing that's direct. So yeah. So again, it has to be, and again, what's the irony, right, is like eyewitness testimony is known to be like the least reliable source of information, right? So eyewitness testimony, confession, or somebody's like on video doing the thing. That's direct evidence. So that's what is needed here, right? For the affiant's state of mind. Direct evidence of the so like in other words, like an eyewitness that can see inside their head, right? You guys see why this is a problem? Ugh. Okay. Negligent or innocent misrepresentations or omit. Oh, wait, hold on. Let's read these footnotes. So reckless means a high degree of awareness of probable falsity. And then whether an omission was intentional or reckless may be inferred in part from the relative importance of the information and its exculpatory power. However, a court need not draw from inferences draw inferences from the evidence in a defendant's favor. Incredible. Okay, negligent or innocent misrepresentations or omissions, even if necessary to establish probable cause, will not invalidate a warrant. And that's Idaho case law. The challenger's attack must be more than conclusory, must be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. They should point out specifically the portion of the warrant affidavit that is claimed to be false, and they should be accompanied by a statement of supporting reasons. Affidavits are sworn or otherwise reliable statements of witnesses should be furnished or their absence satisfactorily explained. Yeah, which one? The Prometheus was the one that was only medical, the one they can tack on for $12. The rest are ancestry. Okay, so if the defendant successfully shows an intentional, unknowing, or reckless inclusion of a false statement or omission of exculpatory information, the trial court must then examine whether the remaining information in the affidavit is sufficient to establish probable cause, absent the false statement or with the addition of the exculpatory information. And, it's probably why they try to include, I'm not saying this happened here, I'm saying in other cases, right? It's probably why they try to include, again, great example for me that I can tell you guys about is the PCAs in the Adelson case, okay? Those PCAs are flawless. If you read those, and we've done it, you're like, they had it more than enough. They're so thorough. It is basically their entire case. And there's maybe a few things they discovered after the fact, at least, especially as it pertains to the first arrests. It's crazy to compare the two. And again, we did it. We compared the two. And as in this, in this case versus there. And, but I was going to say, part of the reason why maybe they go above and beyond with all that, right, is because of this point, right? If anything gets excluded due to whatever, right, fuckery essentially, right? But if anything, in other words, you have all your, you've checked all your bases or whatever, you dotted all your I's, you've added more than enough so that then again, if anything is found, and that didn't even happen in that case, but just again, as an example, if anything is found to be problematic, that you still have enough left. And the thing I keep saying with this PCA is if you do remove the evidence that is contained there for being, if you find that it is reckless or false or any of that, right, an omission, and you remove it, you're not left with anything. So you can see there why, if you're Judge Hippler, right, you have to say that it didn't meet the standard. Because if you do, then you remove it, and now you're left with literally, again, the joke I made earlier, the word "the," right? Okay, so a Franks hearing will be required only if false or omitted information was necessary to finding probable cause. If a defendant makes a substantial preliminary showing under Franks, the matter moves to an evidentiary hearing where the defendant must establish by preponderance of the evidence, 50% plus a grain of sand, that intentional or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. It is at this stage where the state can provide additional evidence for the court to consider. So remember, Ashley Jennings did this part, but she did it at the hearing, and she shouldn't have, and he should. Well, no, let me correct that. Judge Hippler shouldn't have helped her by warning her multiple times not to do that. Anyway, here a defendant claims that 17 search warrants issued in the investigation of the crime were based on false, misleading statements and or omitted exculpatory information in the various search warrant affidavits. His proffer is arranged by issue, of which there are 13. As mentioned, for convenience sake, the court has granted an evidentiary hearing on the IG issue. This evidence will be considered under the preponderance of the evidence standard, while the proffer on the remaining issues will be considered under the substantial preliminary showing standard. So let's read this footnote here. The court was informed that the evidence of this issue substantially overlapped with evidence that was to be presented on the defendant's motion to suppress free genetic information. Given that, the court concluded it would be most efficient to have a full Franks hearing on the IG issue, since it was large. And, in hindsight, it's this was the thing that he said. And I know that was apparently weird. it just makes you wonder if it wasn't just about being efficient. Well, I guess in a way it was about being efficient, but it was like, because again, he already knew he was going to deny it anyway. So it was like efficient because it's like, I don't want to waste my time more than I already am type thing. I mean, sad. DB's back. Woo! Did you think of your command, DB? You've had plenty of time to ponder. Oh, good. Excellent. I didn't even see that. Literally. I didn't even see that. I asked the question. I'm so glad. And by the way, DB, I've mentioned you a handful of times since the last time you mentioned your command. And I've been every now and again, I've been like, by the way, DB is still thinking about his command. Okay, awesome. I will make that right now. Give me just a second, or rather I will ask Nightbot. Okay, hang on. Is that a reference to something? Let's see here. I don't know if there's a parachute emoji. I don't think there's one. I will check. You know, they add new ones all the time. Isn't it so funny, you guys? Do you guys ever go scrolling through the emojis just for fun? And you're like, whoa, that's a new one. Oh my God. I think there is one. Oh my God. I mean, you didn't ask for this, so I can delete it, but let's just see if you like it with the parachute. So speaking of a new emoji, there you go. I don't remember ever seeing a parachute before. Did it pop up? Did it pop up? Nightbot. I don't see it. Do you guys see it? Am I just not? How the heck am I not seeing it? Did it? Nightbot might just be napping. It's entirely possible I typed DB or BD instead of DB. Let's just see. Oh, that rhymed. No, I see it. I see the DB. I just double checked. Oh, he was just. Interesting. It did. Nightbot. Oh my God. Nightbot. 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 Heather's trying BD just in case. I double checked it. Oh my God. Nightbot. I mean, I don't know. I hope we get a flurry of these all at once. That would be amazing. Yeah, 100% it's there. DB. There it is. I see it in my Nightbot. Oh my God, how funny. Weird. Okay, hold on. Maybe I need what Nightbot, are you okay? I'll see if let me see if I can try like unsaving it and resaving it. Let's just see. Okay, let's try it. Let's try it again. Will it work now? Nightbot. Little silly head. He is a cute little Nightbot though. He's so cute. It should, I mean, every now and again, Nightbot he just gets a little tuckered out. I'm sure it'll pop up. I mean, it's there. It's totally there. Okay, so I'm gonna keep reading. Can you guys see it? If you go to the commands, can you see it? You should be able to see it. Maybe he's like, DB took too long. How funny. Okay, so defendant has not met his Frank's burden on issues 1 and 2, challenges to affidavit A9. Oh, footnote 9, rather. Okay, so issue 1 applies to all search warrants. Issue 2 applies to search warrants issued December 29th, 2022 and later. So in issues 1 and 2, defendant alleges Exhibit A, which is a probable cause statement that individual investigative officers appended to their affidavits in seeking search warrants. As defendant notes, Exhibit A was a working document. Okay, this is the thing about how they kind of help each other out. I'm not going to read all that because that's not one of the more compelling issues. Yeah, they worked together. I mean, again, they had way bigger issues than that, way bigger fish to fry, as they say. It's on the commands. Yeah, isn't that weird? Yeah, I did have a space. I added the space because it wasn't working without the space. I'll edit it. I'll take away the space and see if that makes a difference. I added the space because I was like, maybe that'll change it. Okay, let's try this again. Oh my God. Oh my God. I just deleted the space. Let's see if that makes a difference. Tonka's here. That's what TB says. That's okay. It took me a long time to decide, so it probably takes a long time to load the more profound the command. I'm sure that's what it is. Definitely. Okay. I put it in I don't even know if caps make a difference. I've never thought about that, but I put it lowercase on the thing. So, okay. So defendant has not met his burden under Franks on issues 1 or 2. First, it is not improper for law enforcement. Oh, wait. Yeah, we were already saying that this is pointless to read over. Okay. Okay, so defendant has not demonstrated any impropriety in law enforcement's execution of Exhibit A based on collective knowledge. I mean, again, the collective knowledge, I think, is not the most interesting thing here. I'm not too concerned with this. The different law enforcement, I mean, the problems with the law enforcement agencies working together is more like, well, the list would be very long, but it's all things that Judge Hippler doesn't seem to be concerned with. Okay, defendant has not established that alleged, in scare quotes, misrepresentations in any of the 3 challenged search warrant affidavits compels a Franks hearing. Blackwaters command is working. Hi, Sue. The first misrepresentation identified by the defendant in issue 2 is contained in Blaker Exhibit A, supporting the warrant application for defendant's Pullman, Washington apartment and his office at Washington State University. Defendant claims that Sergeant Blaker. Hey, do any of you guys listen to Primus, by the way? Because now that's what we're going to be. Yeah. Sergeant Baker. Anybody? Now we need to listen to that song, but I'll get in big trouble if we play that on here, probably. But freaking amazing. Love Primus, personally. Love that song. It's also a great I love Primus anyway, but it's great music to run to also. Okay, so right, see, now this is all I'm going to think when I see Sergeant Blaker. Oh my God. Oh, it did the thing that it does sometimes. Let's not be stupid. Okay, this is orange now, apparently. Okay. Sergeant Blaker attributes discovering the knife sheath to Idaho State police officers rather than Detective Payne. However, as the state correctly notes, dude, sorry. I'm just like, we learned these orders showed us exactly where Hippler stands on all this. I mean, it's clear. Defendant's challenge is nothing more than a quibble over semantics. Wow. What Sergeant Blaker stated was, I was later advised by ISP investigators they located a tan leather knife sheath laying on the bed next to Mogan's right side when viewed from the door. The other thing is this, because here's my point. He could still, and it happens all the time, a judge could still deny this stuff. Even if it seems like they shouldn't, they still could, but they could do it in a way that isn't so blatantly biased, right? Because it's like agreeing with the state about everything. You could still agree with something the defense said and still find in favor of the state. Entirely possible, right? It doesn't have to be everything the defense said is completely wrong and everything the state said is right. But that's what we're seeing so far. So, okay. What Sergeant Blaker stated was, quote, I was later advised by ISP investigators. Oh, I already read that part. Oops. Okay. Exhibit D2 at Bates 5198. In fact, it was Detective Payne who was the first investigator to discover the knife sheath. That's scary. Once discovered, Detective Payne notified ISP investigators who then collected and booked the sheath into evidence. At best, Sergeant Blaker's use of the word locate is ambiguous as to whether it means discovering or collecting. Under no reasonable reading could it be characterized as a misrepresentation, let alone an intentionally or recklessly false one. Well, vague, I guess, right? Yeah, where is Meg? I don't know. It's weird. Yeah, and we covered, for anyone who didn't see, we covered the transcript the day it came out. Shout out to Twiz for letting me know. He was like, the transcript's out. I was like, stop everything. We're doing that now. I will be honest. It didn't surprise me. I thought it was going to be that whack. I'm not saying it's a good thing or a bad thing. Like, no one likes being disappointed, but also, isn't that a bad thing if like that's the little hopes that you had to where you're not even disappointed or surprised? Like, that was me. I was the most shocked by Brett Payne saying that you can only put one thing in a code at a time. That was the most absurd thing I've literally ever heard in my life. But yeah. Yeah, that was. I hope he says that in front of a jury, because I will tell you this much: no juror is good. He will lose credibility immediately, because the first thing every juror is going to think is, wait, hang on, what about when there's crimes with more than one person who committed the crime, right? Hello, like it. Okay, let's keep reading. So, the second alleged misrepresentations are in Payne Exhibit A, supporting defendant's arrest warrant application, and Mallory Exhibit A, supporting the Google warrant application. Defendant claims that both detectives simultaneously claim to have done cell site. Oh, Twiz! Here you go. Cell site location information, CSLI work, as well as work to determine whether the defendant's cell phone was in the area of the King Road residence. Footnote 12. These Exhibit A's both state, quote, after consulting with FBI CAST, I was able to determine estimated locations for the 8458 phone from June 2022 to present. Records for the 8458 phone showed the 8458 phone utilizing cellular resources that provide coverage to the area of 1122 King Road on at least 12 occasions. Oh, blah, 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 blah. We all know about that, right? In the early hours, morning hours, blah, blah, blah. Okay. Defendant notes, however, that both detectives admitted at a subsequent hearing in this matter that it was actually FBI CAST agent Nicholas Balance who performed the location work that the detectives then used to complete their respective affidavits. That Agent Balance was the individual who actually did the location work does not render the detective statements intentionally, recklessly false, or even misleading. While defendant asserts that the defendants both claim to have done the work, they do not. They claim they were able to determine the locations after consulting with FBI CAST. Both detectives explained in their respective affidavits that CAST was the FBI's cellular analysis survey team. Thus, it was made abundantly apparent to the magistrate that the detectives were relying on work performed by more specialized law. I mean, yeah, we heard Brett Payne over and over and over again say, I'm not an expert, ma'am. Fuck, you aren't. We know. What are you doing? In sum, as to the statements encompassed in issue 2, defendant has not established that a misrepresentation was made. Moreover, even if the challenged statements could possibly be construed as false, there's not a shred of evidence they are intentionally or recklessly false. Finally, even if the statements were intentionally or recklessly included, defendant has not established they were necessary to establish probable cause. Huh? Oh, God. In a common and massive investigation. Oh, my God. He's quoting Ashley Jennings. This is what I'm saying, guys. He doesn't have to be so blatantly obvious. Look at this. Why do you think he said this? I can't. Okay. Well, I held off as long as I could. But there are times in life when one just has to goat. Am I right? Hang on. I'm just shaking my head. Oh, boy. Wow. Disgusting, really? Yep. In a common and massive investigation such as this, which specific member of law enforcement actually discovered the knife sheath or performed the location work using CSLI is irrelevant to probable cause. What is important is that the information came from other law enforcement personnel, which is a reliable basis for the warrant. Well, consequently, Frank's hearing is not warranted on the issue. This is how I feel about this, you guys. Oh my God. I just want to I don't even know what. Already goated. What else can I do? I'm just seeing what you guys are saying. Oh, interesting. Do you live in Sue, do you join us from Idaho? Absolutely, DB. Absolutely. 100%. As soon as these filings came out, I started to go through it. Yeah, I'll just read what DB's comment is here. It occurred to me today that maybe he ruled against the defense so vigorously because he's giving the state a stacked because the case is weak. Yep. I mean, and again, because he feels, in my opinion, he feels like they have the right guy. And therefore there's like literally nothing that you know what I mean? And that's not what they're supposed to do. That is not the law. But that is what judges will do, you know? It's almost kind of like like, what's the word I'm looking for here? It's like that thing of like, it's okay to break the rules or it's okay to infringe on rights, because it's for the greater good, right? Type of thing. Which, for example, right? A great example. Like when we heard from Gabriel Vargas, right? About how how people started first using the whole backdooring thing for the IG databases, right? It started with like, what did she say? It started with like Jane Doe cases or John Doe cases, right? Like unidentified remains, where it was like, okay, like, that we're not supposed to do this, but we're trying to help somebody out here, right? We're trying to bring closure for a family, that type of thing, right? That's how it started because they thought they were doing the right thing. And then I think it morphed into, when they like a criminal investigation, right? Because again, they think they're doing the right thing. They're trying to help. Similar concept, or well, identical concept, really. Exactly, right? And then you have to hear Jennings talk again, and then Hippler was like, yep, that checks out. Absolutely. Yep. He literally is quoting her. When he says massive investigation, he's literally quoting her. Like, wild to me. And let's see if DB's command is this silly Nightbot. What a little silly head. He's so cute. Okay. Oh my God. It worked. DB. You know what it is? Nightbot is just so in tune with the time, like you said, right? The time that you took. I've never seen it take that long. That is hilarious. I guess he felt like it was appropriate. That is so cute. That is so cute. Right? I know. Good job, Nightbot. Yay. Cute. Oh my God. How cute you are, Nightbot. Oh. Yes, indeedly do. Oh, look how cute Nightbot is. We love you, Nightbot. We love you. um, good job, Nightbot. Good job. It sounds like Sue's gonna put out flyers. I don't know. Okay, so Defendant has not met his Frank's burden on issues 3, 10 eyewitness statements. Oh boy. All right, here we have a footnote here. Oh, inconsistent dates. Okay. We need this one. Footnote 14. Insofar as the challenge pertains to omissions regarding DM's reliability and consistency, it applies to all warrants. Insofar as it pertains to her non-recognition of defendant, it applies to warrants issued after December 30th, 2022. For anyone who hasn't heard me say this and hasn't watched Lawyer, you know, do like a review of some of this, right? Because, you know, he keeps his videos short. I'll let you guys know, I've literally never seen him like that. And he was actually the first person I discovered on LawTube back in 2020, because I was watching the George Floyd trial and he was the only person who was covering it. And back then it was like 2-minute videos of where he would just like define like a concept, right? So I've been watching him for ever since, right? And so anyway, I'm saying that because you get to know a certain person really well when you watch all their videos, and you know, to where how their style is, right? And I can tell you without any doubt, I think that he has some choice thoughts about Hippler that, okay, let me put it this way. I think that he tolerates Judge Bev more than Judge Hippler. The way he assessed these orders, and again, he kind of went through, I think he was just doing this one alone, just the Franks, and he went through certain parts of it. And I think he's going to go through other ones too later, but it was like, he was pissed. Like, and again, if you don't watch his videos, you might not recognize it that way, because he's normally so mild-mannered and like respectful towards judges and benefit of the doubt and stuff. I've never seen him like that. I've never seen him like that. It's one of those things that you pick up on when you watch someone a lot and you know how their tone. Dude, he was fucking pissed. And I've told some of you guys, maybe for me tell a story before, but I was listening to it, not watching. I was listening to it while I was watering my orchids. And as one is wont to do when you have 17 of them. And I'm not joking when I say that I stopped in my tracks and my jaw like fell to the floor so many times, because I'm like, holy shit. Like, for Peter Tragos, that is a lot. And one of the things that he got really worked up about was as it pertains to DM. Dude, it was great. It was great. It was great. Did any of you guys see it? Right. And I think he said something to that effect, and then some about DM here. They're not published yet. We will be on the lookout tomorrow. Oh, he said he was doing yes. He literally got, I don't want to say soapbox, that sounds bad, but he literally got on the whole thing of like, what is the point? What is the point of probable cause if it doesn't matter if you meet it? What is the point of a DOJ interim policy if you don't follow the policy? What is the point of this and that and that? He's like, it was all the things that I feel, the rage of like, why are we just pretending we're pretending it matters, but actually saying it doesn't matter, right? Like, it's disgusting. It's disgusting. It's so hypocritical. Oh, it just really, it bothers me on such a deep level, this type of thing. And you watched it. Yeah. Again, just for him, that was, he's always so composed and so, again, gives so much deference, and like, he's so careful with, for him, that was like, I've never seen anything like that with him. So you have to understand that was him, very like, what he thinks and feels is probably a lot more than that. And he really censors himself to be polite and all that, you know? So anywho, and actually it's funny because I watched the rest of the one with Bob, and dude, it was really funny because Bob was like not affected at all. It was really funny, right? Like, to see the difference, because I watched the Lawyer You Know one first, and then I watched the rest of the one from Defense Diaries, and I was really surprised, right? Because normally as a defense attorney, you would think he would have been really pissed. Did any of you guys notice that? It was funny. Peter Tragos was fucking pissed. Pissed. Right? For real. Yep. Yeah. Yeah, he did the hand over the face a lot with both parties. So why do you guys even watch that shit, dude? Y'all, don't waste your time. Okay. So, right. Okay. Right. Okay. Initially, the defendant challenges the probable cause statements insofar as they set forth witness DM's interview descriptions of things she heard and saw on the night of November 13th. Defendant claims that law enforcement failed to inform the magistrate that DM's accounts describing the suspect were variable, that she questioned her memory, and that she did not recognize defendant when provided with a photo of him after his arrest. I feel like at that part, if I recall, Peter Tragos was already starting to freak it the fuck out. Defendant also contends that law enforcement misrepresented statements made by DM that would have demonstrated her unreliability. These allegedly false statements and omissions, according to the defendant, were exculpatory and material. While defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Defendant's own proffer establishes that DM's accounts were remarkably consistent throughout her multiple interviews with law enforcement. And further, the probable cause affidavits are very consistent with her accounts. I'm sorry, what? I just don't understand it. I don't understand it. Second, DM's interview statements that her memories were fuzzy and dreamlike and may have been infected by being tired or under the influence of alcohol do not call into question her reliability to the extent Frank's would require disclosure. Finally, DM's failure to recognize the photo of the defendant is of no consequence. So, literally, it's like saying you may as well have a cardboard box, right? Like, what could be worse than this for an eyewitness, honestly? Like, the eyewitness in the Zachary Hughes trial was a disaster. This is even worse because you take all that and then you add in drunk and all the rest. I mean, oh, God. Great point, right? Right, exactly. And that's the thing. I mean, Hippler, again, it's so funny, right? The things he said in the hearings, we're seeing exactly how he feels. Like we pointed out one earlier where he was like, wouldn't it just add to the probable cause? Same thing with the question where he's like, well, DNA might be enough or whatever. That is not a question. That's what he thinks, that the DNA is enough. And we're really seeing that here now, that those were not questions, those were comments that were unfortunately indicating where he was going to go with this. I think I've heard about that one, Sue. What was somebody asking? And what was your, about prepping her for trial by getting her drunk, probably is what you're saying? Yeah. I wouldn't, if I were the state, I would not call her. If I were the state, I would absolutely not call her. No way. No way in hell. No way. No way. No way. And then what you would be doing is you would just be running the risk of like putting it like, okay, defense falls in your court, or is the defense going to call her or not, right? And depending on what type of shit show her depositions have been and whatnot, that's how they would assess that risk. But they might, I mean, okay, I'm not going to say they're going to do anything smart. I'm saying what I would do is I would not call her. And then again, depending on what I would bank on the fact that maybe the defense wouldn't, because that wouldn't really help their defense, I guess. Well, depending on what we don't know everything, right? It's hard to say, but I would not call her. This is like DM is like a trooper proctor or something. Like, don't call them. I mean, and the difference, right, with Trooper Proctor, they had to because he was the lead detective in the case for Karen Reed, obviously, right? But they could not call DM. They have that option. That's what I would do. I mean, that's hilarious, Heather. That's hilarious, right? Yeah, I know. And I think that the whole thing here is just using her kind of like you know, the way you would use like a disposable something or other, right? Like a dirty nap, like using her just to establish probable cause, although at the same time also saying it wasn't necessary, right? And then, but not bringing her into the trial, right? That just goes to show you, right? And I would imagine there's going to be other things like that were in the PCA that are not going to come into the trial. I would not use the Elantra either. The Elantra is a mess. The Elantra is a disaster. But DM is worse, I think. DM's, sorry, just laughing. DM's accounts were consistent and accurately summarized in the Exhibit A's. The draft Exhibit A circulated by law enforcement include the following description of statements DM made during her interviews with law enforcement. Oh boy. DM made statements during the interview that indicated the occupants of the King Road residence were at home by 2 a.m. and reportedly asleep by 4 a.m. This is with the exception of Kernodle, who received a DoorDash order at approximately 4 a.m. She stated she was awoken by 4 a.m. What sounded like Gonsalves playing with her dog in one of the upstairs bedrooms, which were located on the 3rd floor. A short time later, DM said she heard who she thought was Gonsalves say something to the effect of, "There's someone here." A review of the forensic records associated with the download of Colonel's cell phone indicated she was likely awake and using the TikTok app at 4:12. DM stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. DM stated she opened the door a second time when she heard what she thought was someone crying from Colonel's room. Then she heard a male voice say something to the effect of, "It's okay, I'm going to help you." At approximately 4:17, oh, here comes the dog, I guess, right? Or no, not yet. Picked up what sounded like a struggle. Security cameras less than 50 feet from Colonel's bedroom wall. The struggle lasted less than 1 minute. Unintelligible sounds can be heard on the camera. DM stated she opened her door for a 3rd time. I mean, if the camera across the street can pick up sounds. Anyway, okay. After she heard the crying and saw a figure clad in black clothing and mask that covered the person's mouth and nose walking toward her. And the other thing that's never been discussed ever yet is what type of mask it was, right? Like, was it a ski mask? Was it a COVID mask? I mean, I don't think that that's ever been said. Describe the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. I mean, how do you guys know, like, how do you see the bushy eyebrows in the dark? The male walked past DM as she stood in a frozen shock phase while she was also texting, apparently. As the male walked towards the back sliding glass door, DM locked herself in her room after seeing the male. Oh my God, it's just. Cover his forehead. Okay. This portion of the draft Exhibit A was incorporated in varying degrees into Blaker's Exhibit A. When these Exhibit A's were submitted in support of search warrant applications, DM had sat for at least 3 interviews with law enforcement, 2 on November 13th, one with Nunez and Detective Mallory, and 1 on December 17th. And there's a footnote here, footnote 16. The interview with Officer Nunez is December, or exhibit, here's the exhibits. I've never heard of Detective Lake. Oh, I think we did hear, I thought they were saying Lake in the hearing. Okay, that's who that is. Okay. Okay, so her description of the intruder was notably similar during all 3 interviews. White male, slim, skinny, lean body type, slightly taller than DM, wearing all black, wearing a mask that was covering his forehead and mouth, a voice she didn't recognize saying, "Here to help." How does she know that's the intruder, though? Because she didn't see the person when they said it. That could have been anybody that's male. It could have been, well, I guess it's like didn't recognize, but still, that's not IDing the person. Oh my God. Okay. And the intruder walked out or towards the back sliding door without saying anything to her. While she did not tell Officer Nunez that she noticed the intruder carrying a oh, here's the vacuum. I've heard about this. I haven't read this part yet. A vacuum type. What the fuck, though? Oh my God. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mallory later that day, as well as Detective Gooch a few days after that. She also told Detective Gooch that she remembered the suspect's eyebrows were bushy, but could not remember their color. This is so insane. She likewise told Detective Mallory she couldn't remember the color of his eyebrows. I mean, eyebrows are generally like brown, right? I mean, rarely would you have a different color eyebrow. You guys, honestly, only in very rare instances would eyebrows be a different color other than brown. Even when the hair color is not brown, right? More importantly, not only are DM's statements consistent with each other with regard to the intruder's description, they were accurately included by law enforcement in the Exhibit A set forth above. There's not one statement in the affidavits regarding the intruder that cannot be traced directly to DM's words. It's like, so her own story is proof that her own story, anyway, whatever. Consequently, defendant has not demonstrated an intentional or reckless false statement, with regard to Defendant also asserts that Exhibit A watered down DM's statements about hearing Kaylee Gonsalves around the time of the homicides. DM was unequivocal in her 3 interviews when she reported that at 4 a.m. she heard Miss Gonsalves walk upstairs with her dog before running back down the stairs saying someone's here. Like, that part's insane. In draft Exhibit A, however, law enforcement represented that DM said she heard who she thought was Gonsalves say something to the effect of, "There's someone here." Defendant argues that the addition of the word thought is false, and further, defendant surmises it was intentionally false to cover up the fact that DM was wrong but what she heard. Obviously, what else would it be? Defendant points out that Ms. Gonsalves was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who DM heard running down the stairs at 4 a.m. Defendant contends that DM's misconception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore a probable cause. However, the statement challenged by defendant can be read in 2 ways. One, that DM said, "I think it was Miss Gonsalves," which is how defendant apparently reads it, and which he claims is inconsistent with DM's interview statements. Or 2, that DM said she heard Miss Gonsalves, but law enforcement had a reason to think it could have been someone else. When the statement is viewed in context, the latter makes more sense. Oh my God. That's really sad. In their respective Exhibit A's, Detective Plain and Sergeant Blaker, again, just thinking back to Primus, immediately followed up the challenge statement with the following. A review of records obtained from a forensic download of Kernodle's phone showed this could have also been Kernodle, as her cellular phone indicates she was likely awake and using the Pseudo-Alibi. I mean, through this explanation, Payne and Blaker are effectively conveying to the magistrate why they believe DM's statement of who she heard was questionable. Huh? Well, let me read that one again. Through this explanation, Payne and Blaker are effectively conveying to the magistrate why they believed DM's statement of who she heard was questionable. Then how come the rest of it's not questionable? You've got to be kidding me. You've got to be kidding me. You've got to be kidding me. I don't understand. I don't understand. Thus, the court cannot conclude there's anything false or misleading in this regard. Well, there's a lot of things that can be concluded, but I don't even know. We don't have time to go over all of that. That will be here for 10 years. Oh my God. I know, right? I know. Oh my God, it's just so awful. Oh. Right? In addition, even assuming it was a fault, but oh my God, pulling an Ashley Jennings here, right? Okay. In addition, even assuming it was a false statement, well, okay, the defendant does not establish that it was intentional or reckless attempt to hide DM's alleged misperception, or that her actual statement was exculpatory or otherwise material to probable cause. Consequently, a Frank's hearing is not warranted with regard to statements in the relevant Exhibit A's regarding DM's account of what she saw and heard. And there's a footnote. Based on defendant's proffer, it is not a foregone fact that DM was mistaken when she heard Miss Gonsalves. Couldn't she have been mistaken on all of it then? Fucking hell. Deep breaths. DM reported a thing 4 a.m. when she heard Miss Gonsalves walk upstairs and then run back down the stairs saying, "Someone's here." Miss Kernodle received a DoorDash delivery at 4 a.m. It is entirely possible Miss Gonsalves went downstairs when she heard the delivery pursuant. Wait, weren't you just saying that it wasn't her? It was Zan? Never mind. No point. I can't. Oh my God. Oh my God. Oh my God. Oh my God. Absolutely. That's what he's doing. 100%. 100%. Yeah. No, he's the worst. He's the worst. Yeah. There is a lot of mansplaining here. You're right as well with that, Heather. And we saw it in the hearing, honestly. And what's funny is he did it to both Ashley Jennings and Ann Taylor. And maybe we thought he was being somewhat fair the way that he was like saying things to Ashley Jennings, like, well, that's your answer, right? And it was like, awesome. I wonder if it's really just because he's sexist. Like, so biased, he's always going to side with the state, but so sexist that if you're a woman, he's going to be like, you suck. You know what I mean? I wonder if that's what's going on, because the mansplaining is very apparent. Ugh. Ugh. Okay, let me drink some water. There's no evidence. Actually, that reminds me of something.
There's no evidence of anything in this case.
Thanks, Lolly. There is no evidence law enforcement intentionally or recklessly omitted information bearing on DM's reliability or that such omissions were material or probable cause. Defendant next asserts that the probable cause statements omitted important information bearing on DM's reliability. Defendant notes that DM qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mallory, quote, everything was kind of blurry. Like, I don't fully remember it, I would say. Huh? Pardon? Come again? That's what she said? What? Huh? I don't fully remember it? What are we doing? What are we doing? A few days later, while recounting the events to Detective Gooch, DM stated again, I believe I was also very drunk. Excellent. Sounds great. I don't know how much of this is real. Wonderful. Like, I don't know if my mind was like doing whatever. Okay. I don't know any of it. What is happening? Literally. Like half the stuff, I don't know if it's a dream or if it's real. I just have no clue. This is worse than the way I remember it being in the hearing. This is worse. I don't know if Ann Taylor read parts of this or just seeing it with the grammar in writing, because sometimes that can happen where things are worse. Regardless, I'm going to read it again. For example, she told Detective Mallory, quote, everything was kind of blurry. Like, I don't fully remember it, I would say, end quote. A few days later, DM stated, again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like half the stuff, I don't know if it's a dream or if it's real. I just have no clue. Brief moment here because there's an opportunity before us. Is this the real life? Is this just fantasy? Right. The brighter skies and sea. I'm just a poor squirrel. I need no sympathy. Okay. So she also said her memory was fuzzy and cloudy, as if it couldn't get worse. And she could not, quote, differentiate if anything is real or if anything is a dream, end quote. This, yeah, sounds great. I would not call her at trial. I already was saying that, but just again, to reiterate, this information was not included in the Exhibit A's. According to the defendant, this information was crucial to allow the magistrate to properly evaluate DM's reliability, and its omission was material and exculpatory. The law does not favor the defendant on this argument. Probable cause is determined by examining the totality of the circumstances. And you know what the problem is with this? You know what it is with this? The totality of the circumstances that Judge Hippler is referencing is the DNA. That's it. That's what he can fall back on that. But what he can do is try to bolster that by saying it's the totality of the circumstances. so that he's not being, so that he's not, doesn't have to say that, right? He can just say it's the totality. And making practical common sense decision whether giving all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information, shall be hearsay, there's a fair probability that contraband or evidence of a crime will be found in a particular place. Based on defendant's proffer, it is not. Oh, I already read that footnote. Whether the hearsay supplier is reliable is dependent in part on their status. Unlike an informer from the criminal milieu, crime victims or witnesses are presumed reliable, and may be relied upon without independent corroboration. Well, the funny thing is this, that literally every single study shows that they are the least reliable and are completely unreliable. So that's interesting. Quote, a detailed, okay, before I read this, I just have to say, I was like thinking to myself, what case law is he citing, right? Because I thought to myself, it's probably pretty outdated. Oh, sure enough, it's from 1976. This is the case law he's citing. This is not even, by the way, so this is federal, but it's not U.S. Supreme Court, okay? It's the appellate court level, the Ninth Circuit from 1976. So it's not, that's what you got. That's your best citation that you have there. Quote, a detailed eyewitness report of a crime is self-corroborating. It supplies its own indicia of reliability, end quote. Despite this presumed reliability, quote, police must always be alert to whether other facts which have come to their attention raise doubts about the veracity of the witness, end quote. And that didn't happen? I don't understand. Such facts may include a motive to exaggerate or falsify statements made to law enforcement, or whether the hearsay supplier is a young child or suffers from psychological delusions. What if they were drunk? In such circumstances, corroboration is required to establish reliability. I mean, I will just say this much. A sober young child, I would say, is more reliable than DM. What do you guys think? However, this is not a burdensome requirement. Quote, the corroboration of even innocent minor details can support a finding of probable cause, end quote. Any omissions of facts bearing on an individual's reliability will only be considered misleading under Franks if the omitted facts cast doubt on probable cause. This just all sounds like so circular, like we've already pointed it out before, the circular reasoning. It's just, it is what it is. And if it isn't, it is because it isn't, because it isn't, because it is. I mean, it's mind-blowing to me. It's disgusting, honestly. Did anybody ever watch Parks and Rec, the TV show, Parks and Recreation? And does anybody know, if so, does anybody know DJ Roomba? Because that was amazing. 100%. Young children are always, yep, absolutely. They're reliable to be honest. They absolutely are. Yep, absolutely are. Yeah, that's why this is especially offensive to me as someone who works with kids every day. Oh God. Okay. This just makes me feel nauseous. Like, oh my God, we need to do better. We need to do better. And then again, with this the nevertheless established through other evidence. None of DM's qualifications during her interviews reasonably placed her presumed reliability in dispute. She was a direct witness and was able to consistently articulate the details she remembered through each interview, especially as to the facts relied on in the search warrant affidavits, despite the fact that she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated. Wait. Still intoxicated. You guys, during the interview? Hang on. Let me read that again. Oh my God. She was a direct witness and was able to consistently articulate the details she remembered throughout each interview, despite the fact that she claimed her memory was fuzzy, or that she felt like it was a dream, or that she was still intoxicated. Are you saying still intoxicated during her interviews? What? Huh? No way. Did you guys like what? I don't even know. Honestly. The way it reads though, Twist, you're giving Hippler the benefit of the doubt there. The way it reads, and honestly, this is why words matter and punctuation matters. The way this reads, it's not quite clear, and it really looks like it's saying she was still intoxicated during the interviews. That's what that reads like. Having said that, she was interviewed on the 13th, right? I mean, she may still have been intoxicated. It happens to people. But I appreciate you giving him the benefit of the doubt with that. The numbers, I think, was just a mistake. Because actually, I saw it several times. Or it could have been the court reporter. Like, that's what I gathered. Because sometimes they're referencing the same place, but then it would be 1112, and then it would be 1122. Yeah, right. Well, and the thing is, guys, have y'all ever known, like, there's people that will be drunk like way after. Like, if they're really, really drunk, like the next day they're drunk or whatever, the next morning, right? So, like, if she was really shit-faced, you know, entirely possible. Oh my God. Oh, here's the camera. Never mind. Sorry. You guys were way ahead of me here. So that, okay, this does say 1112. So what I was just said about the numbers on the house, I was referencing the way they discussed it in the transcript for the hearing that just came out. The hearing from the 23rd, but the transcript that just came out, because it looks like they're talking about only, although I don't know. Now I need to maybe go back and take a look. But anyway, this is interesting. So, okay, for example, the security camera from 1112 King Road picked up the audio of a struggle at 4:17 a.m., which coincides with DM stating she thought she heard crying. I heard someone crying. Anybody know The Secret Garden? It's a musical. It was shortly after this she opened the door, and saw, let's see, corresponds with the surveillance video showing the suspect vehicle leaving 112 King Road at 4:20. In addition, law enforcement corroborated DM's description of the defendant through its vehicle identification efforts, which led investigators to the defendant's driver's license information. Detective has shown no objective indication that DM's interview statements were unreliable, particularly given the other corroborating evidence, and therefore no reason for law enforcement to include her qualifications in the affidavit. For this reason, it cannot be said that law enforcement intentionally or recklessly omitted the information. Further, the Exhibit A's inferred that DM was traumatized when they noted that she stood in a frozen shock phase when she saw the intruder. This necessarily alerted the magistrate that DM's memories were colored by trauma and shock, which goes to the issue of her reliability that defendant targets in this motion. Finally, even had the Exhibit A's included DM's qualifications to her memory, it would not have, and there it is, right? It would not, it doesn't matter anyway. It can just be whatever. Who cares? It's just, they still have probable cause. It'd be no surprise to the magistrate that a person experiencing what DM must have experienced would be shaken by, like, this is insane. Like, I'm not saying that's not true for trauma, but what I'm saying is, like, the way that this judge finds every reason to try to explain it and excuse it and would have questioned the reality of what she perceived. This does not render her unreliable. Well, what about the drunkenness, though? It's not just trauma, but drunkenness. And she also didn't say she was traumatized. Literally, she's explaining things because she was drunk and it was fuzzy. She never once said anything about being frightened. Anyway, okay. Additionally, the bulk of probable cause came from other sources, including the extensive vehicle identification efforts. Fucking hell. Thus, even if the magistrate questioned the reliability of DM's account, she had sufficient grounds through other evidence to issue the warrants. I have no idea, Twiz. I have no idea how they know. Probably because she said. You know what I mean? Like, yeah. You're right. It was just a thud before. Oh, Sue lives in Utah. That's cool. I've always wanted to go to Utah. Sue, let us know if you want a custom command because we don't have one for you yet. In sum, defendant has not shown that DM's various qualifications during memory are material exculpatory facts that were intentionally or recklessly omitted, and that would have affected probable cause. It is evident from the applicable Exhibit A's that DM's account was largely relied upon to establish the timing of the homicides and a general description of the perpetrator, not to identify the defendant specifically. Her statements on these matters, and see, he asked that question for a reason. It just pisses me off. But you know what? When he asked that question, it pissed me off at the time. He was like, "Are you using this for timeline or for identification?" And she said both. Both, she said. Ashley Jennings said. Her statements on these matters were consistent. While any perceived weakness in her memory may be fodder for cross-examination, they do not negate probable cause. Yeah, again, I wouldn't call her if I was the state. Yeah, I don't know, Rochelle. It's just beyond me. DM's non-recognition of defendant is immaterial. Like, this is just so dumb. It's just dumb. Heather, I know, right? Call her. She's reliable. Are you turning into Wendy again? Are you in Wendy? Oh my God. Dude. Defendant also contends that law enforcement's failure to include DM's non-recognition of defendant in Exhibit A's warrants a Franks hearing. During her December 30th, 2022 interview with law enforcement, DM was shown defendant's mugshot and asked by Detective Lake whether defendant was the person she saw in her house. DM responded, "I have no clue. From what I remember, I just remember seeing this figure that was more of like a skinnier tone build, some mask on." You don't even know. She doesn't even say what kind of mask. How? I don't know if it was covering his mouth, his nose, or just below his mouth and nose. Oh my God. I just remember he was white, but I didn't know how he was white. That actually, you guys, think about that. Like, think about the Zachary Hughes, right? Remember how it was like the whole thing about being able to say he was definitely a white male when it was like there was like no one of his skin showing, and like they were like pointing at his neck, but like that was by sober law enforcement officers zooming in on the footage after the fact and like examining it with all the technology and whatever the fuck. And even then it was still really hard to see. It was a stretch. So I find this interesting. Like, you don't know how you knew he was white, but you just knew he was white. Like, I don't know. That's a bit, I don't know, like some sort of like racism going, or not racism, but I don't know. What's the word I'm looking for? I don't know. I just find that weird. I just knew he was, and I knew he looked at me because of the bushy eyebrows. If you saw the bushy eyebrows, how the fuck did you not see the mask? Like, when I say see the mask, like, A, what type of mask? And B, how much of his face did it cover? This makes no sense. Right? I know. So just a forehead mask or what? I guess they have to make it so that she sees the eyebrows. I know. I know. Oh, God. However, the fact that the DM could not identify defendant is hardly exculpatory or material. Of course. Dude, I'm over it with this. I'm over it. Her interview statements described a black-clad, masked person who was not someone she thought she knew or could identify. But how can you say that, though, dude? Okay. It would be one thing if you didn't see the person, but you just heard the voice. Because I understand it's possible to be like, oh, I don't recognize that voice. However, given that the voice is on a different floor of the house, And given that you're also admittedly drunk, right? That's the best case scenario, considering all the other things. Am I dreaming? Am I in a frozen shock phase? Whatever else nonsense. Best case scenario, she's drunk, right? Or worst case scenario, drunk, and then other things too, right? So I don't even remember where I was going with that. This just makes no sense. Like, right. I know what I was going to say. Right. So if you're anyone, including DM, right, whether you're drunk or sober or whatever, I would think you could identify somebody, right, based on seeing them, even if they're like covered up to a certain degree. Like, in other words, the fact that she's saying this, sorry, I meant to say that it's just interesting, right? Because it's like, okay, the voice, so she hears the voice and it's like, I don't know that person, right? And then it's like, she sees the person and then she's like, I don't know, I don't think I know them or could identify them. Yet only saw the eyebrows and knows the person's white but doesn't know why. That would make sense if it was someone you knew, right? Like, anyway, this is pointless. Her inability to recognize defendant unmasked is expected, particularly where her description as relayed describes a mask that covers the person's mouth and nose. And I knew it. I didn't even have to keep reading. I knew it was going to leave out the second part of that, or the rest of that statement about the mask. Gross. Thus, because her non-recognition is not material and exculpatory, fucking hell. Defendant cannot demonstrate. It's as if they could be. I would love to see what Judge Hippler thinks is material and exculpatory. Not even in this, in any case. Literally, can he even give an example? I don't think he would be able to, because I think he's just that colorblind, if you will, but justice blind, we'll say. Also, great song, Colorblind. Defendant cannot demonstrate the failure to include this fact in the probable cause affidavit warrants of Frank's hearing. Defendant has not demonstrated law enforcement omitted it intentionally or recklessly, nor has he shown how including the information would have affected probable cause. One simply cannot say that had law enforcement included a statement that DM, unsurprisingly, the commentary of it all, right? The commentary that he adds in. Just like how in parentheses he added massive with investigation earlier, and now this, it's disgusting. Was unable to recognize defendant from a photo, the magistrate would not have found probable cause. If Frank's hearing is not warranted on this issue. Wow, guys. Wow. Now we're on to the vehicle. Fucking hell. Right? I know. I'm with you, Rochelle, on that for sure. Yeah, the vacuum. The vacuum. What the fuck? So when it comes to the vehicle, I've got some stuff I was working on with that. Again, this is before the Zachary Hughes trial. It might be better to cover this, to go over this when I've gone back through that and seen if I'm made sure I'm finished with all of that, because that will be very relevant. But having said that, this just honestly, it just pisses me the fuck off, to be honest with you guys. I'm not sure what this is in reference to, Twiz, but yeah, BTK. Yeah. The torture was an important part of that situation. So I might go ahead and call it here, guys. Did y'all let me know? Did anyone else want to weigh in on tomorrow if you want me to cover the hear and read trial, or not trial, sorry, hearing while it's happening, or if you would rather do that in the evening after the hearing, like because other people are streaming or whatever the case may be. If anybody has any opinions? Rochelle, I feel like I've heard many cases that are like this, so I'm not quite sure which one. I mean, I've also heard it, the dude kills the girl. Like, I feel like this is a very common thing that happens. Okay. Well, it's 12:30 where I am, although you guys know that doesn't really matter to me. Oh, it's supposed to be recent. Okay. Yeah, I don't know of a recent one. Oh, interesting. For some reason, I'm thinking of Taylor Business. Kind of similar. Blamed on the weed. Oh, yes, that does ring a bell. 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 I can't. Okay, yeah, that does ring a bell. That does ring a bell. I don't remember the name of the person, but that does ring a bell. Yeah. Well, we could do, y'all. Well, let me see here. I'm trying to remember if I have that one set up. Let me see. How would you guys feel about some Katie McBanoa? Because the next Adelson stream I was going to do was watching her take the stand in her own defense during her trial. We haven't watched that yet. And I don't even think, well, I'm sure I've seen it, but it's been a while. And I feel like it's been too long since we've done Adelson's. And like, I know Heather's probably going to love this idea. But also it's just, I will tell you, I struggle with this shit, and I can take it in doses before I don't know. And there's nothing I can do about it. Right. But like, it really is depressing, to be honest. It's like just having these standards in place or these rules just to say you have them and then not following them. And then there's just the double standard and the hypocrisy. And you guys know how, like, the thing that I can't stand more than anything in the world. Well, I would say like hypocrisy. I can't handle it. I can't handle hypocrisy. And it's just awful. That's all I can say. It's just awful. And honestly, Judge Hippler is really, there's a certain tone that he has that just is especially offensive, I feel like, to like everything. I don't know. And the mansplaining of it all, right? It's like deciding with the state, but also like mansplaining at the same time. It's like, oh God, it's like all the worst things, like all the small things. Oh my God, Blink-182. It's like all the small things, but all the worst things, like all the worst things. That's Judge Hippler for me. That's where I'm at with it. So let me just see here. I've got this set up. Let's see here. Why can't I type? Let's see. Da-da-da-da-da. Okay. And the thing is like, you know, with Katie McBanois and her retrial, it was kind of unclear like what the defense strategy was. But I remember as we were going through it, I was like, some of this will probably make more sense when she takes the stand, because it seems like they were kind of trying to lay those little breadcrumbs ahead of time for her during the state's case in chief. So let me just see. Yeah. So anywho, oh my God, I know Jennings. Santa is really funny. He's like really temperamental. I know. And Bethany's like, fucking hell, dude. It's like, great question. I mean, I forgot about her. I will be honest, because literally we never hear anything about her. It's weird, right? It's weird. It's weird. Honestly, she'd probably be more reliable than DM, right? Because I mean, you can't get any worse than that, really. I mean, maybe Bethany didn't see anything. That's my point, right? Like she could be more reliable if she was just like sleeping. Yes. Well, that at least she wasn't doing what DM was doing, right? At least she wasn't like in a drunk dream, frozen shock phase, texting people and whatever else the fuck. Let's see here. So, okay. Oh my God, I'm typing. So, all right. Right. Yeah. Okay. So let's do this. Let's do this. Here's what we'll do. We will continue reading through all of these, and I want to read them in full, right? But also we're switching topics to the car. I think what we'll do is we will do this. We will, just for my own sanity, and also just because, again, I also want to make sure I've got those other things ready as it pertains to the car. Let's do this. I'm going to end this stream, and then I will post, can I redirect you guys? Let me see if I might. No, I can't redirect you guys because we're already on this stream. I don't think I can do it. Yeah. So what we'll have to do is end this stream, and then we will start the next stream. And it'll be Katie McBanoa on the stand. So we'll do that. And that way we can have a little bit of a contrast. So how does that sound? But yeah, but I'll just go ahead and get it set up, and then hopefully we will see you guys all here in just a second. So I'll go ahead and roll the outro and see y'all soon.